So the judge in your divorce or custody case ordered mediation. And now you're wondering, what is that and what am I supposed to do and why do I have to do this, right? Good questions. So mediation is a process where you work with a neutral third party who has no skin in the game. They're not on anybody's side, but their job is to try and facilitate an agreement between you and the other party. So the reason that the courts often order that the parties participate in mediation is because the courts in both divorce and custody cases understand that the judge, who is essentially a stranger, is probably not the best person to make decisions about your finances, and if you have kiddos, about your kids, than you would be. And so the court is trying to give you the opportunity to work with a neutral third party and try and reach an agreement with the other side, whether that be your spouse or just your co-parent, to reach an agreement on all of the issues in your case. So that's the purpose of mediation. The cost of mediators can certainly range depending on the mediator that you use. There are some more economical options in Colorado, which is through the Office of Dispute Resolution. So you can use that service. Or if you have friends who have gone through this process, or if you are working with an attorney, they may have some recommendations for mediators that, given your situation, may be a good person to use to help, again, both of you try and meet in the middle and come to an agreement. Generally, mediation is going to be at least 2 hours, but can take as long as it needs to be. You're usually kept in 2 separate rooms. It will depend on the mediator, so these are questions you'll want to ask them to make sure you feel comfortable. But in most cases, one party stays in one room and the other party in another, and the mediator will kind of shuffle back and forth to try and help the 2 sides reach an agreement. If an agreement is reached during mediation, you want to make sure that it's put down in writing and both of you sign it so that nobody can kind of change their mind on the drive home. The other thing to remember about mediation is that it's completely confidential. And the reason that we do that is to allow the parties to be creative and think outside the box and try anything that maybe they can that would work for both of them to reach that agreement. And so when I say confidential, what I mean by that is, say you're in mediation and you offer that you will give your spouse half of the house if they take on some credit card debt. So that's what you offer in mediation. Your spouse comes back and says, I don't want to do that. So you end up in court if mediation doesn't result in a complete agreement, or you guys just can't work out a complete agreement on your own. That's when the court steps in and makes the decision. So you're in court and the judge is asking about the house, and then you stand up and say, I want the house. I want all of the house now. Your spouse can't then raise their hand and go, whoa, wait. When we were in mediation, you said I could have half the house. Any proposals or solutions or offers, counter offers that are talked about in mediation are kept confidential so that the parties have the room to be creative and they don't feel like, well, if I offer this, is it going to be held against me? Are they going to bring it up in front of the court and then it's going to come back to bite me? So mediation is entirely confidential for that reason. You also can't ask the mediator to come in and talk about what was discussed in mediation. So in general, if you stay open, I have a lot of folks who I work with who are like, we are never going to come to an agreement. I don't think this is ever going to work. And we get one. We get to the end of mediation and we get an agreement and they're so surprised, but they feel so much better because they had control over the outcome. That's the other really powerful thing about mediation is that you keep control because you're still a part of the process. So stay open. If it is ordered in your case, don't blow it off. Don't think there's going to be no possible way that there could be an agreement reached. You never know. Be creative. See if you and your other party, either your spouse or your co-parent, can't reach a resolution. And if you do, wonderful. That is always the best possible outcome. Everybody kind of feels like they contributed and they got at least a little something as part of the agreement. If mediation isn't successful, like I said, or if you kind of continue privately to work back and forth and try and reach an agreement and you just can't, that's when the court steps in. So the court wants you to go to mediation to try and work it out on your own. If you can't, then the court will step in, they will hear your arguments at a hearing, and they will be the ones to decide. So when the court does that, you lose the control in that case, because you just make the best case you can and make the best argument you can, but you really don't have a lot of control over the outcome. The court's going to make the decision that it feels best. So mediation is a really great resource. Here in Colorado, it's a great tool that is included in most divorce and custody cases. So if it is assigned in your case, make the most of it. See if you can't use it as an opportunity to reach an agreement.